All right, Tim, you set? This summer, June 2020, the U.S. Supreme Court released a landmark decision that will have profound, unanticipated, and dramatically far-reaching effects for decades to come. This was the Bostock Decision, where the majority effectively included sexual orientation and gender identity as federally protected employment statuses into Title 12 of the Civil Rights Act of 1964, which prohibits employment discrimination on the basis of race, color, religion, sex, and national origin. Each of these are objective things with clear and universally agreed upon legal meanings. The question before the court was, did Congress have sexual orientation and gender identity in mind when they wrote the law? Of course they didn't. Any clear common sense reading of the actual text of the law as written makes no mention of or even reference to either of these. In effect, 6 unelected judges created a radical new law simply because they wanted to. They did something that the legislative and executive branches have refused to do on numerous occasions over the previous few decades. So it's bad enough that the Supreme Court acted as the legislative branch in creating rather than interpreting new law, thus violating our nation's constitutional separation of powers. But what's worse is that the Supreme Court did so through a genuinely convoluted argument based on an absolutely unscientific, in fact, contra-scientific, radical gender theory. One of the plaintiffs in this case claimed that he was unfairly fired because after 6 years of employment, he informed his employer that when he came back from vacation, he was going to, quote, live and work full-time as a woman, end quote. But the court introduces the plaintiff to the reader this way, quote, Harris Funeral Home fired Amy Stevens, who presented as a male when she was hired. And, quote, when she got the job, Miss Stevens presented as a male, period, end quote. Consider these two words, presented as. So was the plaintiff actually a man or a woman when he was hired? Well, here's the facts. Stevens did not present as a man when he was hired. He was a man. And Stevens clearly admitted that he was a man when the funeral home hired him. This is how the court's decision explains what happened. Quote, when she got the job, Miss Stevens presented as a male. But 2 years into her service with the company, she began treatment for despair and loneliness. Ultimately, clinicians diagnosed her with gender dysphoria and recommended she begin living as a woman, end quote. By their own telling, the court got it precisely wrong here. The funeral home hired a male, not someone presenting as a male. The plaintiff himself even admitted this. Stevens says that he was a man every day he showed up from work over a period of 6 years. He went home every evening from work as a man. It was only after the vacation that he intended to start presenting as something else. The court does the same things with the words identified. Quote, or take an employer who fires a transgender person who was identified as a male at birth, but who now identifies as a female. The court is blindly accepting the made-up and completely unscientific gender theory belief that one is not born male or female, but is merely assigned or identified as male and female at birth. And on top of this, the Supreme Court of the United States is also admitting that one actually becomes a real, actual male or female, not by being born that way, but by simply declaring it at some point later in life, like Mr. Stevens did just before he went on his vacation. The court says our maleness and femaleness doesn't exist objectively in the examination of the body and its genetics and in every strand of its DNA, but only in one's subjective self-understanding and self-proclamation. And how often can one change that self-understanding, and under what circumstances? Now get this, according to gender theory orthodoxy, I could have changed my gender 3 or 4 times in the course of this presentation. And the only way to determine the truthfulness or falsehood of that claim is my mere insistence on it. There is no external objective criteria the court or anybody else can appeal to tell me I'm wrong. All I have to do is to claim that I'm gender fluid, and that's the end of the debate. Therefore, according to the Supreme Court in Bostock, I can use the restroom of my choice at any place that I've ever worked, and there is nothing they can do about it. I can leave for my lunch break as a male, and I can return as a female every day if I want to. You think I'm being ridiculous? Healthline.com, claiming to be a serious medically reviewed source, explains it this way, quote, "Some gender fluid people feel that the changes in their identity are extreme, while others might feel that they're arbitrary. Their gender might change quickly in a matter of hours or slowly over months or even years. When they realize their gender identity has changed, they might or might not change their gender expression, how they dress, how they present themselves, for example, or even their pronouns." Obviously, this decision in Bostock is one of the most radical and consequential in the court's long history. That's because it redefines what it means to be male and female. And that will create untold serious problems for employers, problems we cannot even begin to fathom. They've already started trickling in to the lower courts. And the court offers no explanation or rationale for why it simply adopted this radical assumption about sex or gender. It just accepts it wholesale. As written in law, everyone knows and is in agreement on what they are and what they are not. The two just added by the court, sexual orientation and gender identity, are inherently imprecise and subjective. Even the LGBT community itself and the gender theorists can't even agree on what sexual orientation is and is not. Same thing goes with gender identity. As Justice Alito said in his brilliant dissent, he said, quote, "It defies belief to suggest that the public meaning of discrimination because of sex in 1964 encompassed discrimination on the basis of a concept that was essentially unknown to the public at the time," end quote. He is exactly right. Gender theory was essentially unknown at the time, and clearly our understanding of sexual orientation and gender identity are not as obvious and agreed upon today as the court would have us believe. Mark my words, the court created a mess in Bostock that few of us can fully fathom. That's what happens when you redefine what it means to be human as male or female. Think about that.